Mr. Mulledy.
Chief Justice, and may it please the Court, Christopher Mulledy for Bradston Associates. The auditor for the City of Boston certified this contract as executed with one word.
Well, somebody in the auditor's office, right? I mean, isn't that an issue, whether the person that did it was authorized to do
It's
so?
not an issue. The authority of that person is admitted not only in the Statement of Undisputed Material Facts, but in the brief itself. Furthermore,
Two issues here, don't we? The first is, I guess, the one the appeals court passed on, which is whether the contract itself the second one is, if it does, whether the performance of the work.
They are, Your Honor. They're two separate issues, but there are certain common threads that run through both of them, and I guess I can refer to those briefly now. One is that, according to the Sheriff's Department, when the word executed is used or signed is used in a contract or in a certificate by the auditor, that word executed has nothing whatsoever to do with the idea that the execution of the contract was authorized. But another common thread here is that a defense can be made to the language of a certificate formally executed by a government officer and to the language of a fully integrated contract on the basis of the unilateral subjective intentions, alleged subjective intentions of a party, and that government officials are not bound by the statutes that regulate their contracting authority, because they can claim ignorance of them and try to establish that that a contract is executed months before the statute says that it can be deemed to be executed.
Article 12.2 of the general conditions in 0. What kind of endorsement is that? That's not a fiscal approval, is it?
It certainly is not a fiscal approval. That's correct. It was given at the outset of the administration of this contract. She says that she did it for the purpose of expediting the contract and causing it then to go through months of review by the mayor's office, the office of the Corporation Counsel for the city, and the Sheriff's Department and the Sheriff's CFO.
Kicked in on January 2nd when the word executed was added, and then there was a reference to the project grant number, which of course is admittedly concerned operating budget, and then it was a total amount not to exceed $6 million something.
6.8.
That's correct.
And was it further signed by the auditor at that point?
It was signed by the auditor's authorized representative, Cynthia Johnson. Now,
Point when it's kind of up to speed, right?
sure.
I'm sorry to interrupt you, but that 6.8 in the line item, had the budget actually been passed at that point?
It was passed days before it was passed on December 1st in that year.
And what's the date of that document?
And the date of the mayor's approval, I believe, was December 4th. The sheriff's CFO signed off on the contract as the representative of the awarding authority on December 12th, and returned it to the auditor as he was required to do by the city's standard procedures and by statute that regulates the city's contracts.
And this date is January 2nd.
And this date is January 2nd. That's when the auditor finally acted on the contract. Now,
Was this a specific line item, the $6.8 million?
this is the way that contracts are routinely executed for the Sheriff's Department.
No. That was a specific line item in reference to, what is it, House 1 or something like that, whatever the statute is that's executed by the legislature?
That's right. That year it was
December,
Chapter 177 of the Acts of 2001.
Million is a specific line item. It's not part of a general appropriation.
No. It is a general appropriation for the Sheriff's Department's operating budget, and this is the authority that the
part of
sheriff.
the general appropriation, how do we know that the money is for this specific project?
this is the authority that the sheriff uses for all of its operating expenses, all of its lease expenses. And the fact that that this contract was executed was squarely admitted in the executed with spending authority, was squarely admitted in the statement of in response to the statement of undisputed material facts.
That is your contract figure, right?
The contract figure is $6.8 million.
So that dollar figure there, isn't that referencing your the amount of this contract, but it's a piece of the larger line item amount. Is that right?
The larger line item amount is the funding for the operations of the sheriff's departments for the various counties.
Right.
General operating budget.
That's correct. And the sheriff uses its spending authority under the routinely for lease expenses under that line item. What happens is that the County Government Finance Review Board establishes a budget for the sheriff's department for the year. The legislature has stipulated minimum amounts to be dedicated to each of the counties. In this case, it was $75.6 million. That was dedicated to the operations of the sheriff's department for Suffolk County.
Testimony in a deposition, as I understand it, that would lead a reasonable fact finder to conclude that the auditor had approved this project and the money was there.
That's correct. And not only that, but the availability of spending authority was squarely admitted in the statement of undisputed material facts. It was laid out on page 94 of the record. At paragraph 1, the statement says, when the lease documents were finally approved by the City of Boston's auditor and stamped executed, the Sheriff's Department had spending authority to enter into this lease, citing to the testimony of the Sheriff's CFO. To make it abundantly clear what I was talking about, I included in the statement of legal elements the following language. No contention is raised that the commitment of funds in line item 8910-0, no contention is raised that this commitment of funds and the budget authority that it carried with it, upon approval of the sheriff's operating budget by the County Government Finance Review Board, was in any sense insufficient to support the execution of this lease.
So how did the appeals court, in your view, what did the appeals court sort of miss all this, or the appeals court?
With all respect to them. With all respect to them.
That's the respect you feel?
With all respect to them, I hope that nothing is going to
Everything's recorded, so if you don't want to comment on it, that's
Hang out
fine.
over the internet.
with all respect to them, yes, they did. This
mute button's
is
on.
an area that many judges are not terribly familiar with.
I'm reasonably
Well, Judge Van Gestel is...
That's correct. But Judge Van Gestel overlooked some basic principles. He doesn't discuss at all what the executed certificate on this document means. And to get back to your question, your initial question, Justice Botsford, there's no dispute that executed is a certificate. Nobody's questioning that.
I thought they was questioning that.
They're not questioning that in form is a certificate. The second thing that they're not questioning is that the person who executed it had the authority of the auditor to execute it for its full legal effect. They're not questioning that either. What they're saying is that the auditor somehow didn't intend to give her, didn't specifically intend to give Cynthia Johnson the authority to approve the contract that she was causing to be awarded, that the auditor said was fully executed for the purposes of being awarded, that somehow the auditor didn't specifically intend.
Is there testimony to that effect? Is there something in the record that raises a tribal issue as to that point? Did the auditor intend to give this person...
Well, it's not a tribal issue at all, Your Honor, because
She's bound by an agent
because she's bound by the authority that she gave. She caused a certificate to be attached, a formal legal certificate to be attached to this document. And I'd refer the Court to a case that wasn't cited in the brief, but I didn't want to leave any stone unturned here. Commonwealth versus Smiliano, 427 Mass 490 at 494, in which this is a statute that refers to an operator of a breathalyzer test having to be certified by the Secretary of Public the statute requires that the capabilities of the operator of the breathalyzer be certified by the Secretary of Public Safety. And the court held this is the kind of thing that the Secretary of Public Safety obviously can be expected to delegate to other people. There's no dispute here that the auditor does, in fact, routinely delegate her authority to execute specific certificates that specifically use the word appropriation. She does routinely delegate them to other people. But
Can I get to it? Can I get to a different? You can finish your point, but I have a point I'd like to ask you about.
This certificate is no different than if it had said executed under Chapter 262, than if it had said, I hereby certify that the sheriff is fully authorized to sign for the department, than if it said all conditions precedent to execution have been satisfied, approved as to funding. Any of those would have been the substantial equivalent of asserting that funds were available for this contract, that fiscal authority was available for this contract. And when a government officer who is responsible for the administration of government contracts puts such a certificate on a legal document, intending that it be awarded, intending that it be held out as binding, she shouldn't be surprised if that's exactly the effect that it is given.
Now, let's go back to the beginning of this. I take it when this contract was first terminated, the Sheriff's Department took the position, didn't challenge that the contract wasn't valid and in effect, but challenged the fact that the 6 months should have begun to run in August when it was, quote, signed, unquote, by one or both of the parties. It was only after that came back from the appeals court and that issue was discounted that, in fact, the Sheriff's Department took the position, well, there was never a contract to begin with.
That's
it was
correct.
properly authorized. Secondly, so that's my understanding. That's a correct understanding.
It is.
That right? The second question is this. The contract is indeed for not to exceed $6 million something, but it is clear that money was not to be spent in that fiscal year. That was for the 10-year life of the contract, right?
The $6.8 million was the figure, the face amount of the contract for the 10-year life of the contract. That's correct.
So certainly there wasn't $6.8 million in the budget.
That's
the fiscal
correct.
budget for this, correct?
That's also correct.
And ordinarily, as I understand, these contracts, although they may say that, they are indeed subject to annual appropriation.
This contract, in fact, says that.
Right. So if you were to have gotten the money for the fiscal year, in other words, whatever the costs were, I think there was a $300,000 cost or something for improvements, and then whatever the lease payments would have been for that fiscal year.
That's right. It was $625,000, assuming that every month remaining in the fiscal year
Right.
was a rent month.
So assume you have a clear right to that. What if, in fact, there was no authorization in the following year to pay the lease for the following year?
Well, the law, and this is not disputed, the law under cases like Salisbury Water is very clear that all that is necessary is an appropriation for the first year of the contract. Otherwise, the government would be in a position where it can't execute contracts for long term without essentially impounding all of the funds at the outset of the term. And when they have that,
surely it can, and I understand, as I recall it, that there is a good faith requirement that the government will seek to fund these, the agency will seek to fund these, but that is one of the problems with public contracts for leases, is that they do stand in some jeopardy. Isn't that correct, or has that jeopardy been completely removed?
That jeopardy has been completely removed to this extent that the government has an obligation to fund the contract in future years. It cannot actually pay out without having the appropriation, but if it does not pay out, it's subject to damages under the contract. This is the trade-off that the government has because it is allowed to enter into long-term contracts. It actually has to be bound by a long-term contract.
But
funds
if the city council doesn't appropriate the money in the following year, what happens?
Go to breach of contract.
You have a damages remedy. You go to court and you say they've breached, they're not paying.
Even though the payments are subject to appropriation and there's been no appropriation?
even though the payments, it's precisely because the payments are subject to appropriate, what
Can I have a case cite on this? Because I don't understand this.
Well,
If you bear with me, just.
Is it in your brief? Just tell me if it's in your brief, then.
It is in the brief, Your Honor, but it's U.S. Trust Company versus the Commonwealth, 350 Mass 394, 396, saying that the words subject to appropriation do not make liability contingent on future appropriations.
Can I ask you one more
That's
thing?
what that case stands for.
All right.
Yeah, and your time is up. This is very brief. Assuming we find the contract to be valid, is there a triable issue as to the 6 months? In terms of, is it from the date the sheriff signed it, in which case I guess there might not be performance, or is it from the date that the mayor signed it?
There isn't a triable issue with respect to that for this simple reason. The contract was not executed by the sheriff's department on August 13th of 2001 because the sheriff had no authority to bind the sheriff's department at that time. He didn't have it on August 13th. He didn't have it on August 16th.
Well, the problem with that is you've got this elliptical language in there that says, quote, the signing of the lease.
This is the elliptic language that precisely the elliptic language, which I think is quite clear on its face. It doesn't say before the signing of this lease. It says after the signing of this lease. It was chosen by the drafter, the sheriff's department. When they chose that language, they chose it with Chapter 262 right before them.
Okay.
Thank you, Mr. Malady. Mr. Folkman?
I'm leaving Mr. Folkman a wet pond, I'm afraid. Thank you. Okay. Apologize.
No problem. Mr. Folkman?
Thank you, Madam Chief Justice. May it please the Court. There are two routes under Chapter 262 by which a contractor could show that a contract is binding as to the department. The first, of course, is the principal issue here, which is whether the auditor made a certification of an available appropriation. There are several reasons for concluding that never happened here. The first, of course, is that the face of the Form CM-10, the standard contract, says that an appropriation is available in the amount of
What do
zero.
you say, though, that there was no dispute that executed, the later executed, acts as a certification?
There certainly is a significant dispute. In fact, I believe that's one of the major issues in the case. Both Cynthia Johnson and the auditor herself have testified that Ms. Johnson had no authority to make an auditor's certification of an available appropriation. And I would refer Your Honors to...
What was she doing?
The testimony of Ms. Johnson was that she would stamp the contract as executed when it was returned to the auditing department after it had been signed by everybody who needed to sign it. And this is not a certificate that ever saw the light of day. Once the contract had been executed and returned to the sheriff's department, it sat in the files until it was discovered in the course of discovery here. So this is not the kind of certificate that informed the sheriff's department of anything.
In other contracts of the sheriff's, are there other ones, as was suggested, that just have that executed on them, not the auditor actually saying, I certify, et cetera, et cetera?
The sheriff's department has no knowledge of the role of the executed stamp. Frankly, the first time we saw it was in connection with this case, so I don't know what the auditor's department has.
When did the plaintiff see it?
Excuse me?
On what basis was the plaintiff proceeding?
The plaintiff was proceeding at its own risk. In fact, the plaintiff testified, and this is the testimony of Clifford Long, its principal, that it understood that it was doing the work at its own risk because
That's between the time of August and the time that there actually was an appropriation and a sign-off by the mayor and some form of certification by the auditor. Surely that was a period of risk.
That's right, and that's 5 months of the 6 months of construction.
But
That
the
doesn't
other
make
side
any
never
difference.
saw the executed stamp, as I recall, until they got it in discovery in
Correct.
this case. So they never went to the bother of seeing that this was a appropriately marked.
Correct. Not
contract.
only did they not go to the bother of seeing whether this
Were they
contract...
told that it had been executed?
No, the executed stamp is...
No, I mean, when did they first learn that the appropriation had been made?
I don't know when they learned that the appropriation had been made. We certainly never told
But
them.
does Ms. Johnson have no authority at all to do this?
That's correct. She had authority to stamp the executed stamp. Our position is that the fact that she did have authority to do that and that both she and the auditor testified she did not have authority to make an audit for certification simply goes to show that the executed
What does
stamp...
executed mean?
We don't believe really it means anything other than
Well,
the
that's
contract has
Have
been...
a stamp.
Well, are you saying this was a mistake that Ms. Johnson made?
No, no, no. We believe this is simply a ministerial stamp that she placed on it to indicate that everybody who needs to sign the
Well,
document
if
has
everybody
signed it.
needed
Then
to,
she
that would
wouldn't-
include the auditor.
But then she went ahead and put in that the money was there.
I'm sorry, I don't understand.
Didn't she say executed, and didn't she write project grant number,
It's
total
already there.
amount not to exceed 6.8 million? Who
The-
did that?
The project grant number appears in what's called the chart field on the Form CM10, and there's no dispute that that is a reference to the fiscal year 2002 appropriations bill, line item 8910.
Was this money appropriated?
There was an appropriation in gross for the department's entire budget, but there was no
Total
appropriation.
amount not to exceed 6.8 million also appeared as part of the executed on the face of the contract, did it not?
Yes, the number of 6.5 million does appear there.
Well, who put that in there?
That is, I believe, the sheriff's department put that there.
Right. Mr. Folkman,
And
excuse
it's
me.
correct, isn't it?
The way the appropriation works every year is that there's an appropriation in gross, correct?
Yes.
So it cannot possibly be the position of the sheriff that just because there isn't a separate line item, the money wasn't appropriated.
No, let me be clear. The money,
was appropriated.
Yes,
There was money here for this contract.
correct, there was
and
money
there was
here.
a contract that was signed, stamped, executed.
Yes, stamped,
By
executed.
the person who always stamped executed. It wasn't some fly-by-night summer intern who didn't know what executed meant.
Correct. However, let me make 2 points, Your Honor. The first is that the only evidence in the case is that Ms. Johnson was not authorized to make an auditor certification. And if,
She was authorized to stamp executed.
yes,
And that meant completed all the steps that were necessary.
Your Honor, both Ms. Johnson and the auditor testified that the stamp did not have anything to do with the availability of an appropriation, and I'd refer...
But you're agreeing that the appropriation was available.
The issue, there is an issue that's been raised, this is the Lawrence versus Falzerano issue, and the issue is, well, if there's enough money to pay for the contract, what's the problem? And I'd like to discuss Lawrence in the context of another case as well, the Clark against Fall River case.
Was
Both-
there anything holding up this contract? Anything holding up this contract other than the appropriation going through?
Well, the only thing holding up the contract is the absence of an auditor certification.
Well, I mean, you're just talking in circles. In other words, it was the party's intention that the contract would go forward. Obviously, you can't execute a contract until the money has been appropriated, correct? The money is appropriated. The sheriff has conceded the money was there. Somebody says executed. It's ready to go. I don't know why everybody had a falling out, but the notion that there wasn't a contract strikes me as being absolutely bizarre.
Well, let me make a couple of points, Your Honor, with respect. The first is that we didn't raise, as has already been pointed out, this is not an issue that we brought to the attention of the court in the first instance. In the first instance, we sought to dismiss the case on the grounds that the contract work had not been completed within 6 months. Bradston interjected the statute into the case in order to show that there was perhaps an ambiguity about when the 6 months began to run. The testimony from Mr. Yachts, the chief financial officer of the Sheriff's Department, is in fact that the department was not aware of the statute at the time. Be that as it may, there's some evidence from Maureen Flaherty, one of the department's lawyer, that perhaps suggests that the department was aware. But in any case, it's not an issue that we interjected into the case.
No, but it's a perfectly valid explanation. Somebody is proceeding at their risk, knowing, I assume, that if the money hasn't been appropriated, they may not get paid.
Correct. And no one ever, the executed stamp, as I said, remained in the bowels of the auditing department. It's not something that anybody ever showed to Bradston to say, now money has been appropriated, now you can go ahead. There's no reliance.
How was it going to get out of the bowels of the auditing department? How is this contract going to get appropriately treated?
In a $0 certification, and there are other instances of these. For example, there's a contract relating to 33 Bradston Street, another property at which Bradston is the landlord. The initial certification was for $0. The auditor subsequently has, on documents that have been referred to as purchase orders, although no goods are being purchased, that's what the accounting software calls this document. The auditor has included a certification of an available appropriation in language similar to the $0 certification on the Form CM10. No one has ever challenged that. The department takes the view that those certifications of available appropriations are correct and comply with the
It seems to me
statute.
that the real dispute here is whether or not as Justice Glaney has focused on, whether or not there was, there was compliance with the 6-month period.
Well, we did not move for summary judgment on that point, Your Honor, because the appeals court held that there was an ambiguity. However, I think if this case were to be remanded, the answer would be obvious. Neither Mr. Long nor Mr. Gordon, the two principals of Bradston, had ever seen Chapter 262, so there can't possibly be any evidence that their intention was that the 6 months would run from the signing of this lease construed as Bradston
Were
now
there
wants
any
to construe
payments
it.
made in 2001?
Excuse me?
Were
No
there-
payments were ever made.
And why not?
Well, ultimately, the first payment was not due until after the construction was completed, because the lease period, the 10 years, didn't begin to run until that date. We terminated the lease because it was not completed on time, and therefore no payments were
So
made.
really, to accept your position, we have to find that Ms. Johnson had no authority to do what she did when she wrote that,
No, I don't.
and that they should have known that.
With respect, Your Honor, I disagree in one respect. It's simply been assumed by Bradston and frankly by some of the questions that the executed stamp is the equivalent in some sense of an auditor's certification.
In
The executed
chart
stamp?
field, no, in the chart field, the number, the figure.
6.5.
Now, quote, project grant number SUFO 2056, which is admitted as the quote, total not to exceed 6.8 million.
Well, I think it's
Like a certification to me.
well, it's frankly at odds with what the auditor has certified. She's not certifying that
Well, who put that on there?
that's the sheriff's department. That is simply an identifier for what the contract is. It has nothing to do with the auditor's
Oh, the
certification.
sheriff put that in there.
Correct. Now, I should say that at the time that this document was generated, that bill, Chapter 177 of the statutes of 2001, had not been enacted. So at the time that was put
Don't
there,
these people know what they're doing?
the procedure here certainly leaves, and the relationship between the auditing department and the sheriff's department is complex.
You got the auditing department who says the senior accountant has no authority to do an awful lot of things, and then you got this thing, which apparently the sheriff, you now say gratuitously inserted into the contract.
Let me make 2 points, Your Honor. The first is that I think that the SUF 02056 issue comes into the case not under the question of whether the auditor has certified an amount as available, but rather whether she has cited a statute under which the contract can be executed without an appropriation. Now, by the nature of what an appropriations bill is, Chapter 177 of the Acts of 2001
Well,
cannot
why do you
possibly...
say that, though? Why are you saying that's the piece of 262 that applies here?
Because the auditor's certification of an available appropriation is quite explicit on the face of the Form CM-10. It's unrelated to numbers that appear elsewhere on the document. It simply says 0.
Isn't the real issue here whether or not the work was completed on time in accordance with everybody's expectations? I mean, isn't this a massive red herring?
I don't believe so, Your Honor. I believe the statute says what it says. I believe that, the policies of the statute are sound. I believe that...
Well, its execution leaves a lot to be desired if the policy is sound.
Well, Your Honor, let me make a couple of points. First, this issue of the relationship between Suffolk County and the city is something that's under active legislative consideration.
It may be, but I mean, that doesn't deal with this issue.
That's correct. But given the statute as it was in force at the time of this contract, it's quite clear that the auditor did neither of the two things that would make the contract binding. She neither cited any particular amount that was available as an appropriation other than 0, and she did not cite a statute that permitted execution of the contract without an appropriation. Those are the only 2 routes under the statute to make the contract enforceable. Now, there's another argument about whether there's been substantial compliance or
Well, that's the Falzerano case.
Lawrence versus Falzerano and Clark against Fall River. And what I want to say about those cases is that they involve cases in which the additional action that the government defendant said ought to have been taken would have been entirely superfluous. So, for example, in Clark, the mayor signed the contract on behalf of the city. He was the contracting officer. He didn't need to sign again to indicate that he had approved it, because obviously he had, in fact, approved it. Similarly, in Lawrence against Falzerano, there was a specific appropriation for the contract. The money could not be spent for anything else. Therefore, it was merely superfluous to require a certification that the money had been set aside, because that is what a specific appropriation is. In this case, the auditor certification explicitly is 0. So the principle that you can look at substantial compliance or look at other reasons outside of the statute that the contract should be binding.
Unless you get over to what Ms. Johnson put on there, and apparently what the sheriff put on there, perhaps this is a triable issue for a jury.
Perhaps it is. I don't believe so, Your Honor. I think there's nothing in the record linking that executed stamp to the availability of an appropriation. All the testimony from both of the people who would know, Ms. Johnson and the auditor, is that
She
it...
just stamped executed any day.
Nope.
Tuesdays was her day for stamping executed.
No, it's the end of the process by... What we believe executed
Agreed
means...
that by the time she stamped it, you agreed that the appropriation had been made.
Correct, but there was no appropriation for this contract. And
knew that.
precisely the reason that you need an auditor certification is that...
Somebody told her.
Excuse me?
Somebody told her. She didn't, or she read it in the Boston Globe or the Boston Herald or saw it on Channel 4, 5, 6, or 7, because she knew she couldn't put executed unless there was money there. There was money there.
Your Honor, if this were a case where the executed stamp had been displayed to anybody, such as Bradston, for example, and Bradston could say, well, we relied on the stamp, that would be one thing.
But
What
why
we believe...
lying?
That's a red herring. I mean, they might have been a total loser for them if they didn't have that executed stamp, but if they found it afterwards, then that makes it a valid contract.
What we
Good
believe...
for them.
Your Honor, what we believe the stamp means is essentially that the contract has been signed by everybody who needs to sign it. That's both consistent with evidence in the case. For example, in the lease agreement itself, the parties agreed that the contract would not become binding until it had been executed and delivered, indicating that executed in and of itself doesn't mean binding. The law dictionary defines
And
executed
is there
simply as meaning
anything-
signed.
Anything to suggest that if this had gone to the auditor, was it a she at the time?
It was a she.
She was it
rejected it?
Ellen O'Connor? Who was it at the time? I don't forget.
Laura. Ms.
Whatever.
Laura.
She would have not signed it.
She did reject it, Your Honor, and in fact, it's a good thing she did by certifying that no money was
That
available.
was much earlier, wasn't
And
it?
in fact...
When no money was available.
Yeah,
There
that
was
was
no
way
appropriation.
back.
That's correct.
Way
And in
back.
fact, Your Honors, the defendant has, if I see my time has expired, but if I may finish my answer, the plaintiffs have pleaded, in fact, that the Sheriff's Department didn't have the money to pay for the contract.
Better put a GPS on the hands of some of these people when they're reaching for stamps.
Thank you.
Thank you, Mr. Folkman.